And coming up last, we've got Guido Governatori from Data 61. Bit of an interesting note. 16 years ago, Guido was actually supervising Ben's undergrad thesis, I believe, or something like that. So there's a connection between these last two presentations. Guido leads the software systems group of the research activities on computational law and legal informatics at Data 61 CSIRO. He received his PhD in legal informatics from the University of Bologna and has held academic positions at Imperial College London, Griffith University, Queensland University of Technology, and the University of Queensland. His research interests include non-classical logics and their applications to legal reasoning, autonomous agents, and business processes. He served as chair for all major conferences on deontic, logic, and legal informatics, and artificial intelligence and law. And he's the editor for the Norms and Agents section of the Artificial Intelligence and Law Journal, and the Logic corner of the Journal of Logic and Computation. In 2016, he won the Gold Award for the Australian Computer Society ICT Researcher of the Year. Please welcome Guido.
Thank you. Well, okay, I know it's late, it's Saturday afternoon, and then, well, I'm going to have a very, very demanding task. I'm going to speak about law and mathematics. So essentially it will be the best way to end a public conversation. Okay, so, but again, you signed for it. Okay, so today I'm going to present the research activities we have done in the past years at Data 61 and previously at Technical. Okay, well, let me start with a motivation, again, a quite recent motivation. About 1.5 years ago, the Treasurer Morrison said, the Holy Grail, it's when we started to actually write regulation and legislation in code. Imagine the productivity gains we can get, saving, of instantaneous certified compliance. Okay, well, I think it's a slightly more authoritative view than mine. Well, again, whether we trust it or not, it's something different, whether it's fake, whether it's political or not, it's different, but again, it's in a position of authority at this moment. Okay, now, and again, the issue was about compliance. So what about if we can automatically certify compliance, and then can we have huge savings? Now, one of the problems is, well, when we have legislations, we have many different legislations. Now, suppose you want to open, well, you want to run, let's say, a food van, and you want to operate in Southeast Queensland, let's say, across Brisbane and the Gold Coast. Can you guess how many regulations you have to comply with? Just try a guess. What do you think?
I don't know, 5.
5? Oh, they wish. Better? Much higher.
100?
Oh, no, it's only between 17 and 35.
Oh.
So yeah, it's easy. And then essentially, well, in most cases, as a business owner, you have no idea about what the regulations are, and essentially you have no idea about what are the changes in the regulations and so on. And mostly, you don't care. You're interested in your business. You don't want to waste time in compliance with them. Now, well, let's see some statistics about compliance. And, well, actually, I have just updated this figure here, which is quite interesting. Now, if you look in US, it's approaching 2 trillion per year, and for official sources. In Australia, in 2015, it was, well, only 119 billion. And now, well, this is a statistic I just got from a set of slides and from a colleague of mine. It's 250. So it's a huge increase in just in less than 3 years. And then if we look at from an employment point of view, in Australia, about 1 million people are working in compliance-related activity. And it corresponds to 10% of, about 10% of the workforce. So essentially, well, 1 person out of 10 people, it's working on compliance and it's not working to produce to the core business of the organization. Well, okay, if they work for lawyers, they do, but in most cases they don't. Now, take this example here. For the federal government, there are 66,000 contracts per year with a total of about $50 million. And then the average value for a contract is between $1 and $2 million, 1.5 and $2 million. And there are 20 to 25 bids for every federal government. But then when you submit a bid, what you have to do, you have to comply with the procurement legislation. So essentially what you have to do, you have to spend several months, or well, engage some consultant and spend a lot of money to ensure that your bid is up to the commas precise according to the regulations and the laws for procurement. Otherwise, you'll be excluded immediately. But then, as I told you, there are about, depending on the contract, there are 20 competitors. It means that only one will win. 19 will do the job for nothing. They will not get the money at the end. Now, look, let me back here. Imagine the productivity gain you can get. Well, actually, we don't have to imagine. We did some experiments, and then one of our results is, well, if you take, let's say, or at least some of the techniques we use in computational law, you can save 30% of the time dedicated to compliance. Now you can do your math. Okay, so that was the opportunity, and then essentially, well, how can we approach? Can we propose a way to solve the regulation problem? Now, so essentially what we do, we see an opportunity. And essentially the idea is what we work right now in what we call regulation as platform. Now, so, oops. Yep. Sorry, oops. We work on regulation as a platform, and again, here is a big opportunity, and the idea is to build a new industry based on regulations, and essentially we want to build technology where essentially regulations are immediate to you, and essentially you can build almost automatically applications that ensure that you comply, and they guide you, they navigate, they help you to navigate through the regulations. And again, here we're in a reasonably good positions because in most situations, in most cases in Australia, we have very good and precise regulatory frameworks. So at this stage, those regulatory frameworks can be seen as a burden on organizations, but if we provide tools to address them, and we provide tools to work in the proper way for them, we can see them as an opportunity to create a new industry, and also then we can give back time to the stakeholders for organizations and eliminating the cost of compliance and give them opportunity to innovate. Now, so this is the platform we have in mind, and essentially what is the idea? At this moment we have regulators, and at this moment regulators, they write regulation, well, it's their job, and it's up to politicians to decide what are the regulations. And then, essentially, well, what about if we have some way to translate, to replicate the regulation from their manifestation in natural language as they are now into a logical representation. And then the logical representation then has some form of endorsement from the regulators. And then, well, after those regulations are in this format here, we can have a database for those regulations. Then we can create APIs. And then if those forms, if those logical representation of the regulations are endorsed by regulators, you have APIs. They are released by the regulators as open data, and there are APIs. Then essentially what you can do, you can build applications, you can use your creativity to create applications to help the economy. And essentially you don't have to worry about the regulations, you don't have to worry about to get the regulations in your applications because they will be provided and they will be endorsed. Again, big shot. But that's the idea. And then on top you can build applications. And then here, well, what we have, and I'm going to show you some of the demos we have built on. So, well, if we have them here, then we have several advantages because then, well, once we have the regulation in a digital format, well, then essentially we can look at them. We can reason with and about them. So essentially what we can do, well, from the regulator point of view, we can see to understand what are the internal relationships between different regulations, whether there are some possible conflicts between the prescriptions in one regulations in other. And then essentially we can improve the writing of regulations, we can streamline regulations and to make them better and more efficient. And then essentially, well, after we have them, we can build applications. And then essentially, if you operate directly based on the regulations, then you are certified to be compliant by design. You don't have to call auditors after. Well, at the end, it will not be avoidable, but we can simplify the work for auditors. They will have just to check for particular things, and then we can also to automatize some kind of checks. And essentially, well, you will get a better experience for the community and the business owners. Okay, now, what to do is to translate manually, or we can look at to use some techniques from artificial intelligence, natural language processes, to semi-automatically, or I prefer to say semi-manually translate from textual provision in natural language to their formal representation. Okay, so let me spend a couple of minutes on explaining you my view of computational law, and it's a bit different, or it's, well, it's the part that Evan didn't really touch deeply in his presentation. Okay, now, here's what test I have. So this is a piece, well, let's say, it's a kind of it's a realistic, or realistically looking like a small fragment of a privacy act. And then this is a text I usually use, well, to determine, well, if the audience is mostly from lawyers, computer scientists, and also I can distinguish whether from lawyers, the type of lawyers they are. Okay, so consider this piece of regulation here, and again, it's not real, but it's very similar to what you will get in the Australian privacy principles. So essentially here we have three sections. The first section says, well, it is an offense to collect personal medical information. It is a defense to the prohibition of collecting personal medical information if an entity immediately destroys illegally collected personal medical information before using it, before any access to it. However, section 2 gives some derogations, some exceptions. So, well, if well, you all work based on a court order, then you are entitled to collect personal medical information. But then, on the other hand, we have the last condition that says it's totally forbidden to collect personal information unless you have the permissions to collect personal medical information. For the sake of this exercise here, then we have that personal medical information and personal information only are totally disjoint. Just for the sake of the example, let's say that the personal information is your date of birth, and then the medical information is your blood pressure. So they are totally independent in different pieces of information. Okay. This is the, let's say, well, hopefully a little bit more comprehensible for humans. And then, well, if lawyers didn't do jobs properly, you would get something similar. If the lawyers did the job properly, it would be in the previous format. And essentially said, well, you cannot collect medical information. In case you collected illegally when you were not permitted, if you destroy, you're done, it's fine, you're excused. You can collect medical information if you have, if you're authorized by court order. Collection of personal information is forbidden. Collection of personal information is permitted if collection of medical information is permitted. Okay. Consider this very, very complicated business process here. 3 steps. So let's say that we have an entity, and then, well, there is no court order, then they collect medical information, then they collect personal information, and then, oops, they realize that they collected the medical information without authorization, so they destroyed it. Is this process compliant with the Act? So that is my question, and essentially, well, depending whether you're a lawyer or a computer scientist, you will get totally different answer. So what do you think? So raise your hand if you think that it's compliant. Okay, you're a computer scientist. What about if you think, well, non-compliant? Okay. 3 lawyers? 4? No. Okay, well. Okay, not computer scientist. Actually.
I'm a computer scientist.
Oh, okay, that is true, okay. You are the first exception, great. And well, actually, for lawyers, actually, you have 2 answers. If you ask to a judge, it's a non-compliant. If you ask to a lawyer, the answer is, it depends. And they say, well, whatever you want, I will argue for you for whatever you want. Okay, now, if we look here, essentially, well, you cannot collect medical information unless you have a court order. So the collections was illegal. So you were not permitted to collect medical information. And then the only case where you can collect personal information is when you were permitted to collect medical information. And in this case, you collected without permission. You collected this one when that was not permitted, so this collection was illegal, but you were excused by this for one of them, but not for the other. Now, so essentially, if we just look at the legal intuition, this process is not compliant. However, essentially, all the existing frameworks, but one, they will tell that the process is compliant. What's the problem? They don't do proper legal reasoning. So let me just give again a very, very brief idea about what we have to look at if we want to have legal reasoning. And again, plenty of other issues, but let's say that it's doable, and then what should we look at? So a legal system essentially it's just a collection of norms, and then essentially what we have that each norm is a clause, and then typically we can represent norms as if-then rules. So in the if part, in this part here, A1 to AN are the conditions under which you have a norm is applicable, and then C is the effect you get from that particular norm. And then essentially we can distinguish two types of norms. In some cases you have norms that will define terms. So essentially if you look in contracts or if you look in acts, you have a section which is typically called terms and definitions, and then you will have essentially in this particular document this term must be understood in this way. And then you have the other conditions, where the other conditions they just define the prescriptions, and then so when you look at the normative effects, we can distinguish between obligations, we can distinguish permissions, prohibitions, and then we have to consider violations. Then when you see the structure when the norms are written, and actually here, in this particular example here, we have all the elements here. So essentially, well, we have, well, there is a prohibition, then, or an obligation not to do something. Then the prohibition, well, you can violate the norm. You give a baseline condition. The baseline conditions as a possible exception, so it's defeasible or in legal reasoning. And then essentially you have some permissions, and then you might have obligations, violations, prohibitions. So essentially here, in 10 lines, we have, all those elements defined here. So essentially, if we can do in 10 lines, well, what about if we have 120 pages or 200 pages? You will have plenty of those concepts here. And then essentially, what you have to do, we have to build systems that are able to handle those concepts, and then they should be able to handle baseline conditions plus all possible exceptions to those conditions. Okay, then probably we can skip this one, yeah, for interest of time. Okay, so now I want to show you what we have done in this area. So let me move and I'll show you a couple of applications for the final part. Now, as I said, well, what we do, we were working on regulation as a platform. So essentially, in the platform, at this moment, we have several components. So here, well, we can create several domains, and then we go one step back. So essentially here, it's that the portal for this platform is already available. The URL is raap.d61.io. If you want, you can access. There is a very, very lightweight login, so just give your email address and then choose a password. And again, we comply with Australian privacy principles. And then essentially what you can do, there are already existing many encoded rule sets, and then essentially you have many features on those rule sets. So let me see, let's go to what I've just created. For today. Well, this is essentially what you will get in wrap if you just consider that small privacy principle. There is a small, sorry, actually, this I'm going to show after. It's not the principle, it's the example I'm going to show after. So essentially what you can do, you can create some rules, and then you can edit, and eventually if you have the corresponding text, you have features, you can add the new terms, and so on. So essentially you have an editor to write regulations, and then here you can connect with the text blocks from Apple legislation. So you can select, and again, we have a good set of already, and we get the legislation from commonlaw.gov.au, which is the official repository from Australian government. Well, then when you have them in, essentially we have some additional features to do some analysis. Well, we can visualize the structure of the rules. So this is the structure for those 5 rules, or 6 or whatever. And then essentially, well, you can do in different ways. You can do some analytics. You can say how many terms you have, how many rules, and etc. And then also you can also try to do some debugging. And debugging essentially means, well, what about if I run a test situation? What you can do, you can just select some of them. Again, this is usually given. And then you call execute. And you will get a long list, and at this moment it's it's not very comprehensible at this moment. You have to know what you're looking for. But essentially here you say, well, something is forbidden, something, something is true, something we don't know, something is permitted, etc., depending on the particular situation. So essentially it gives you a snapshot of a legal situation. Now, then, based on this, what we did, we looked at several applications. This is one application we did with the Fair Work Ombudsman, and essentially as well, it's about the modern award. So essentially the idea is, you are in some industry and you want to know what of the current awards apply to your situation. And again, it could be a very, very complicated issue. So what we're going to do here, what we have, we encoded, if I remember right, 6 or 7 awards. There are probably 50 at this moment in Australia. We just did a small sample. So you select a particular industry here, just any of them. And then essentially, based on the selections, you are given some questions to answer. Here are some only particular field, and again, I'm just randomly selecting something. So I don't know whether it makes any sense or not. And then, based on the provided answer, it automatically computes the next set of answers, or to see whether we are already able to determine the award. So here, what you see from the answer provided in the previous page, it just said, well, this is possibilities and so on. So essentially, check one of them, you can select. Let's say this one. And then essentially, based on that selection, it will automatically compute the next set of questions to answer. And again, it takes a bit, but keep in mind that essentially what we have, oh, okay, that it was easy. So in this case, we got immediately the case, or if we want to go back, we want to select something else. It will just go and then do some computation, and this, nothing is has been hard-coded. The only thing which has been written is the translation of the awards in our internal language for the representation of the norms. Oh, the first step again. Okay. probably have to choose something else. Again, I have no idea what I've checked. Let's see another one, but whether we go directly to something else. And again, you can change, and then this is everything done it automatically. The only thing is you have to provide the initial input, which is the industry sector, and then based on that, you have an initial set of questions. Everything else in this case here, you have 4 remaining questions, and again, just select based on your situation, and then it will compute for you. So, well, that was the award that applies in that particular case. And I have no idea what case, because that it was randomly selected for me. Now, the other applications will be, it's more complex. This is for, let's say, enterprises. So, for example, here what we have is about what we call business process compliance. It's called rigorous. Now, suppose that we want to determine whether your process for a procurement complies with the procurement regulation. So here what we do, well, we can choose the examples. We can look at this is an already built process, business process for procurement. And again, it's not really important what it's here. Then on the other side, we have, well, the relevant regulation here. Again, we did, well, some part of the relevant regulations. And again, we have a bunch of set of rules. And then, based on this, what we can do, we can automatically check whether the process is complete or not. In this case, yes, luckily, this one is done appropriately, but well, let us consider other examples. Well, again, this is traffic lights in Naples. So essentially, well, so we have 2 possibilities for the color of the traffic light, and then essentially, well, whether you can stop or you can stop, and then essentially go or not go. And again, we designed that as in Naples, well, it doesn't matter, go anyway. And then we can see what are the rules, and says, well, if it's green, well, you have to cross. If it is yellow, but you're in a stopping distance, well, you have to proceed to the intersection. If it's, well, it's red, then, well, you have to stop, obligation to stop. And yellow, and it's stopping distance, and emergency, then you can still cross. And again, what we can do, we can check whether it's compliant. In this case, we have some issues in the process, in the input process, etc. It tells us where are the issues, and essentially some possible way to recover compliance. Okay, so let me go back then to the presentation, and let me move to something related to blockchain. So this is the other area we want to use our techniques. So, and let's speak about smart contracts. Well, as it was said before, well, I would say at this moment, smart contracts are not smart and are not contract. So essentially, what is it now? We don't know where they are. And then I think over 1 year ago, in another conference, I was asked, well, what's your definition of a smart contract? And they said, well, what about if you say it's a self-executing script running in a distributed ledger technology? Oh, that's perfect definition, but it's not sexy. So, well, we have to live with the definition of smart, with the term smart contract. Now, so essentially, what we looked at in the past 1.5 years, and it's whether the issues of smart contracts are legally valid. And then, well, now, there are many, many issues to determine if, well, something that looks like as a contract is really a legally valid contract. So one of the issues is whether the intent is clear, whether the terms are clear, whether there is, let's say, common intent, whether both the party agrees, there is an exchange of value, etc., etc. So mostly, for smart contracts, we concentrated about the understandability of the languages in which smart contracts are written. And essentially here we just look at this aspect here for, well, what we prefer to call digital contracts. Maybe they're not smart. Now, if we look in literature, well, the idea of a contract or digital contract, it's not novel. So the technology has been around for a long time, I would say more than 10 years. However, well, why do you want to have a contract? So a contract typically is an agreement between parties, and why do you want to have an agreement that offers legal protection to both parties? Because there is no trust about the other parties. Now, suppose that we want to implement the terms or the contract or the terms in the contract in a computerized form. And then there is a contract between me and Graham. Shall we run the contract on my machine or on your machine? And then essentially here we have the assumption that there is no trust in the other party. If there is trust, there is no need to have a contract, because the contract will offer the legal protection. Now, if Graham doesn't trust me, well, we cannot run on my machine. If I don't trust him, then we cannot run on his machine. So essentially, the solution would be to have that the contract is hosted and run in a trusted third-party platform. And essentially, one of the problems were there were no trusted third-party platforms. And blockchain, with smart contracts, offer a solution to this problem here, because essentially, well, the trust is built in the blockchain, in the way blockchain are designed. And then essentially, well, if you have smart contracts, you can write programs, and those programs are self-executed in the platform. So essentially, you don't have to have machine or frameworks which are explicitly built to run a contract between parties. Now, so one of the issues is, okay, now let's say that we have we can run processes and contracts, smart contracts in the blockchain. Now, what about the clarity issues? Well, consider this example here. Suppose that there is a contract, and then that contract is between Donald Knuth and Richard Stallman. I hope that all of you know who they are. And that smart contract is written in a particular language. It's an existing language. And yes, that will be the effect if you try to write in that particular language. But again, being Donald Knuth, essentially one of the fathers of computer science and programming and algorithms, probably is going to be able to understand. And of course, well, Richard Stallman probably is also able to understand. He prefers to write things in assembly, or if I really have to do in C. So yeah, no problems. So now if we have the same contract, but it's between, let's say, well, Donald Trump and Hillary Clinton. So, is the program clear for the parties involved? Well, we might have some doubts here, but we might have an assumption, well, they may be able to understand. Well, what about in this situation? Well, actually, if you look at the tweet of Trump, probably it will be easier to understand the program than what he writes in tweets, but that is enough. Yeah?
They don't have to understand if it's a smart contract, because the contract will execute according to its code, irrespective of whether Donald Trump and Hillary Clinton understand.
No, it will not be legally valid, because essentially you have to understand what the contract is about.
Oh,
you have to understand the terms of the contract.
That's a legal contract. I thought you were
Yeah.
talking about smart contract.
I'm speaking whether a contract is legally valid.
Oh.
So whether a smart contract is legally valid. So essentially, the clarity requirement, it's a requirement for an agreement or something we might consider an agreement to be considered legally valid in most of the contractual law, practically in every jurisdiction. So essentially here we might have an issue here. Now, so what we do essentially, we have a comparison between declarative of logic-based approaches versus imperative approaches. So in a declarative, essentially you give a statement, which can kind of be true or false statement. Or if you are familiar with functional programming, it will be similar to what we can do in a functional programming language. While in an imperative language, essentially what you do, you hard-code the single steps. Essentially, let's say you have go-to statements. Well, let's say something like that. And then we look at what are the pros and cons of those approaches. Now, what we did is we just take, yes, another example, and well, if you were unlucky to have, well, a license from NICTA or Data61, you will get something very, very similar to this. I was not in, again, well, I've modified something here to make it even worse, but I wasn't responsible for the original version. So essentially here you have, well, if you have an license, you can evaluate a product. However, you have the prohibitions to release any evaluation unless you have an approval from the licensor. But if in case, well, you publish something, well, you have to remove immediately or within 24 hours. Again, you cannot have comments on what you were doing unless you have the permissions to publish. And then, but again, if you are conditions to do an evaluation from the licensor, then essentially you can publish the evaluation. And essentially, well, if you are in a breach, then the license to use the product is terminated. Now, here we consider three possible approaches to model this one. So the first one is to say, well, what about if we represent as a state machine? Essentially, a state machine is just, we can represent a transition system where we have some activities, some actions, some transitions, and then essentially we can move from one state to the other, and then we can also label these states whether they are legal or not. And then essentially, well, what you get is if you just consider these 5 clause contract here, you get this state machine here. And then this is just for those 5 conditions. Consider a contract of 100 pages or a contract of 20 pages. You will have a state explosion, so essentially you will not be able to create the state machine. It will be too large, it will explode, it will grow exponentially. So it's not really possible. Well, so essentially we say, okay, well, what about if we look at an imperative way to look at that? Well, and essentially kind of, let's say, go to a series of instructions to represent the contract. Well, if you do it this way, what you have to do, well, if you have a state machine, well, then it's quite easy to write the contract from the state machine in, let's say, solidity. Well, this is pseudocode. We have also in solidity. And essentially, you have to think about the order, and you have to know in advance the order in which the operations must be done. And then for every time you do something, you have to update all possible state, all possible legal situations. Essentially, you have to manually do it, and you have manually to understand, okay, now if I do this, then I have to change that provisions from provisions to true to false, and I have to say that it's not permitted, etc., etc. And then you have to do it, and then essentially you have to care about the order in which the operations are done. And it wasn't too bad, it was about 90 lines of pseudocode. Now, the other thing is to do in a declarative fashion, and essentially using some of the languages we've developed in the language we use inside RAP, the evaluation of the project, and then what you do, you will get a representation like this. So essentially, we'll get there now. Those 3 rules will kick immediately. Then, if you have that, well, there is a license, you have that this rule will kick in, and then essentially now we are permitted to use, and then you have that this rule here, these conditions override. So that one, so I will get permitted, use it permitted instead of use it forbidden, and similar for the other one. So it's much more compact. Hopefully it's much more to understand, and then using the tools we created, you can write in a language which is hopefully and arguably more understandable than the other approaches. So let me conclude about smart contracts, and well, unfortunately, smart contracts, or digital contracts as we prefer at this moment, are beyond what the current blockchain technology is capable of. So essentially, you cannot write them. You have to have the implementation to run behind it, and then at this moment, it's well beyond the capabilities of current blockchain and current block language and smart contract languages. Thank you very much.
Thank you, Guido. All right, questions? I've got a question. Regulation as a platform is a very cool concept. I mean, it's not something that I think or that I know of any other government doing. What's your experience with it? It's certainly not something that I've heard of any other government doing last year.
No, for what we know, no, it's something totally novel. Now, we are experimenting here in Australia, and again, we're just doing some very small experiments with some government. We are working with New Zealand government as well, and probably New Zealand will be a much earlier adopter than Australia. And again, simply for the scale, it's smaller. So essentially, well, the cost in case the platform screw up, it's less than in Australia. And then, well, anyhow, there are some other approaches, so other countries are somehow interested. There is some interest in Estonia and UK. In UK, already the legislation is available in some digital format, yet not logical format. We are working on some legal standards, one of the structural representation of the document, and in UK you can get in that particular format. We are proposing a second standard we call legal UML, and then essentially there are some initial evaluations to use in UK and in other countries.
I'm going to ask one more question before I hand it over. Have we moved in terms of going from human written or human understandable legislation to machine code first? I know that that's something that's been proposed, but I'm not sure if we've actually moved to that stage in terms of creating legislation and putting it out to the platform yet. No,
at this moment, essentially what we do is text first and then translation from text to code. Yep. Now, if you look from in other approaches, well, Lawrence Lessig proposed, well, it's code as law and law as code. It's a famous book he wrote a couple of years ago, where essentially it promotes the idea, well, what about if we have rule first and then natural language after to improve the readability of the rules, but we are not there. But again, one of the issues, and we are considering and we are evaluating and we want to experiment, it's whether it's possible to change the state of mind of legal drafter to write rules and then translate to natural language. So we had a couple of workshops with OPC, the official drafter from the Australian Parliament. They were really easily able to capture the format we use and say, yes, it will be very, very helpful for us now, even now, to use some form. However, tools are not yet mature for them. So again, the editor is still, we're still working. And then it's another aspect you have to work in is to improve the natural language parsing, and it should be both ways. So essentially from natural language to rules and from rules to text. So at this moment, if we want to have the change of mind, we have to have a good rule to text parser or translator, but that is much less simpler. Well, it's very complicated, but it's much less simpler than the other direction, from natural language to rules.
Firstly, thank you very much for your talk, very interesting. One of the examples you gave of laws that you had in the system that were had been passed was AML CTF. Now, we know that certain AML compliance provisions are very easy to automate, like transaction more than $10,000, report to Austrac. But My question is, when you have provisions like the suspicious transaction reporting one, where the law gives you a whole lot of wiggle room to determine what a suspicious matter is, and gives you all these indicators, like you can put in the code the indicators, but how do you deal with a company that is not exactly sure if it's suspicious, but still has to, you know, deal with the logic-based law?
Now, yes, so what we have is what you mentioned, it's what it's in literature are called, let's say, open text returns. So it's probably it's very well known. And then essentially what you do, and then it's here where we can use, we can create a RegTech industry, and essentially it's up to the creator of applications on top to give the definitions, additional definitions which are not necessarily in the law, but whether they occur in secondary or other or second in some form of secondary documents, or based on the best standards. So for example, if you want to go for the data breach regulation, well, what you can do, well, you can take, well, big company working in security for a long time. They have quite good ideas of what are the standards, what are suspicions, transactions. If you look at the database for banks, they have some rule system to determine, okay, this is, it's a bit fishy, let's put some star and let's watch this. And essentially here what you can do is, you have a regulation, and then for those open text returns, you supplement, and again, the platform is open because you can write whatever rules you want. And keep in mind, we have two sets of rules. Those for the definitions, and those for the provision. And then if you want to add more rules, or if you want to connect with databases, or if you want to use some neural network to provide the underlying factor data, yes, you can do it. You can plug in databases and etc. in the platform, and then to consume with the rules.
Sorry, a question. For the tool you showed, you through a browser you were able to navigate that flow and generate. So who could be the user of that tool?
Well, we've been trying to work it out for the past 5 or 6 years. So we don't have a clear market answer. So essentially, well, at this moment we think for writing the regulations, hopefully will be regulators, so government agencies. But again, it could be also, well, consultancy companies. And they essentially, well, you might see, well, you might have an official authorized version by a government, but essentially if you are, let's say, PwC or any of the other big four, or again, if you are a consultant, you can create your own interpretation, and then you can provide it to your customers, your interpretation of the regulation. And again, the issues will be what will be the trust, what will be the value of those rules. So if the rules comes from the regulator, you know that essentially, well, probably it's a little bit better, because essentially they come from them. So again, you will never have a certainty. The certainty will be when you have a positive case in court, otherwise you don't have certainty. But if some rules come from the government and from the regulator, well, the regulator cannot, essentially will not be able to say, oh, I gave you the wrong rules. Now, if you are a consultant, well, you might have a liability insurance, and essentially it's what you put for the trust. If you just take some rules which are created crowdsourcing and from anonymous from the web, we have an idea what will be the value and what will be the quality.
There we go. 2 more questions here.
Yeah, so my question is that, so you're talking about a trust here and talking about the regulatory as a platform. So now I think if something we are just wrapping around in APIs, like this is I think what your idea is ultimately, that if it is coming from the government. So what could be the transparency mechanism we can see in it, or the disclosure, like if you have a document of like it's kind of a narrative, everybody can see what's written in it. But if something is coming as a wrap thing, so how the end user they can see the transparency in it?
Again, it's closely related to the other issues about trust. Now, the mechanism we provide and the basic APIs, essentially, whenever you get a conclusion, whenever you get let's say, something is forbidden, you have a complete trace. So essentially you can say, well, you get these particular conclusions because we have applied those particular norms on those particular facts. So you have a total trace. And then essentially the APIs will allow you to expose that part. When you build in additional applications, well, it depends what the applications will do. And again, it depends again. So it's not different when you apply, let's say, well, you just do internet banking with your bank.
So
Where's the trust?
yeah, so for example, if we come up with a quite complicated application in which there are a lot of regulations being implemented simultaneously, and it becomes kind of a neural network kind of a thing, and we have a lot of nodes and they are just generating something, so you're just providing input and ultimately you're getting output. So sometimes it will become a quite
what you will do, you will have a complete trace, so you will know exactly for every conclusion what are the rules used to derive that particular conclusion, and you can build a justification based on the rules you used. And you say this rule is from that particular app, this rule is used here, and it's from that particular app, and for this reason here. So essentially you will have a full traceability. So it's not like a neural network that essentially you don't know what are the internal connections. Or it's, well, as Benjamin showed, well, it's, well, I just have the pixel, and then if the machine has been trained to say, well, if you have those pixels, it's female, if you have those pixels, it's male. Here, essentially, you have a complete trace for the explanation. And again, then it depends on the applications you build on top. If the application on top completely hide, again, that is the advantage of that particular application.
All right, we've got one last question over here.
Hi, Guido, thank you very much. Every time I hear someone from Data 61 talk, I think you blow my mind, and you've got the coolest job. I think you guys at Data 61. Thank you, it's fantastic. I have a very, very simple question, and that is in terms of state-based legislation as opposed to federal. Are you guys looking in that space as well, or no, or not yet?
Well, theoretically, yes. It's a bit harder to get engage. Well, no, it's not harder to get engagement with them for us. It's it's about typically, depending on the state and the department, it's a bit harder to get funds from them. So actually, at this moment, we are engaging with a couple of agencies in New South Wales to do a couple of trials. Again, I don't know what will be the aim, and again, first we have to prove that the platform works, and we will start with federal, where essentially we're from our federal status, where it's easier for us, but also we are not ignoring a state, and essentially, yes, the platform will be able to accommodate federal or state. And also, we can go even lower, you can go even to council, but
Let's thank Guido, everyone. So that's it for today. Thank you all very much for sticking with us here. I know it has been a bit uncomfortable because of the air conditioning. We're on again tomorrow. We're going to start at 10 a.m. We are running our accelerator tomorrow morning, and then we're going to have our global symposium starting at 1 to 2:30. So if you're interested in contributing to that discussion, and it's going to be awesome, I would encourage you all to come before that, and that'll be immediately after lunch from 1 to 2:30. We'll be live streaming again, going out to the 45 different nodes that are participating in this with us, and it's going to be a great time. After that, we're going to have the conclusion of the accelerator, where we are going to have very short 3-minute pitches for them between 4 and 4:30. So if you'd like to stick around for that as well, it's going to be a great time. Thank you again very much for coming today, and I hope to see as many of you as possible tomorrow.